Welcome to Sovereign Citizen Legal Encounters. All right, we're back in Judge Webster's court where the sovereign citizen has returned. He's part of the group that has been trained. The other two I covered recently, where now they have attorneys. So I'm wondering in this hearing, is he going to have an attorney? Well, we'll find out when we go in. So I want to show you the first hearing that he had with my commentary already, and then I'll jump in on the next one. Let's go.
We will now take up Matthew Schrader on the record now in 2025 TR 1342, State of Kansas versus Matthew Kyle Schrader. Jared Regier for the state. Mr. Schrader, do you appear?
I'm here in pro persona sui juris, appearing specially and not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve two charges. Count 1, failed to register a vehicle and classified non-person misdemeanor. Count 2, no proof of insurance, a class B non-person misdemeanor.
And you said these were allegedly committed when? Which state, according to the document?
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
And location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive my right and present myself.
All right. Is anyone making you waive your right to an attorney today by any threats or promises?
No.
Or any other reason?
No.
All right. And you do understand, for the record, that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
All right. I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney. You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count 1, fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the U.S. mail. If you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
Now we're going to switch to another hearing where his partner, sovereign citizen, said the same thing. Let's go.
I trust then that you wish to go to trial on these matters, Mr. Hutch?
Not at this time. I'm not sure if you've been made aware, but I have requested a subpoena via a precipice that I provided to the Butler County Clerk on August 14th. That was directing them to subpoena records from the Butler County Sheriff's Office with a production date of August 22nd at 5 p.m. That date has come and gone now, and I am still awaiting the subpoenaed evidence that directly affects these charges. However, via some hearsay this morning on the phone with the Butler County Clerk, I was informed that the sheriff had motioned to quash the subpoena. I'm not personally received anything in writing as of now that shows why the sheriff would want to quash a subpoena. As such, I'm moving this court to continue this matter until I've had ample time to review and respond to the quash.
Now you heard both versions, and obviously they're working together because the script is almost the same. Think about the other courts that we watch. None of the other sovereign citizens present their script like that.
All right, you have filed a written motion for subpoena of what documents from the Butler County
Subpoena
Sheriff?
Ducis Tecum.
Of what?
There are many items on there, and
So you don't know what you've asked them to bring to court?
yeah, I do. I don't have it in front of me, but it's a lot of the typical things like body cam, dash camera footage.
All right, and they have filed a motion or a response to quash at least part of what you requested.
Yeah.
Right, and Destiny, do you have both his motion and the response on the file there in front of you?
I show the subpoena, Your Honor, and then I show the
Motion.
sheriff's office motion to quash.
Okay, all right, well, we will set those for hearing if necessary, but how do you want to plead on these charges before we get to that?
Well, I feel like it wouldn't be appropriate to plea until I get the evidence and I'm able to be informed enough to make an appropriate plea.
Of course.
All right, so you're telling me you don't want to plead not guilty today, you don't want to plead anything today, is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me?
Judge Webster may have thrown him off his script.
I'm asking you, sir.
How much time I need?
No, I mean how much time the whole hearing will you anticipate will be?
20 to 30 minutes.
All right, let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena Dulcis Tecum in motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information in this before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
The written response in motion to quash does appear to be filed by Mr. Hulskamp, Your Honor.
All right, let's set a motion hearing on a Wednesday afternoon. Destiny, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but
And you do want it on an afternoon, Your Honor?
yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day.
What are you
November.
looking at? I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Schrader. Do you understand that?
Yep, sounds good to me.
All right, if there's nothing further, let's
Your
see.
Honor, there are multiple matters still to address.
Go ahead, please.
Your Honor, as given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being set, requested, and this matter is being set over by the defense.
Speedy trial time does count towards the defense if he is asking for this motion hearing to be set and that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that since I appeared here as I was supposed to.
I think that question got him also.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by the officers for booking and processing. Your bond will be set at a 3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with deputy in court security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post the 3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
It seems he's getting lost and doesn't know what to say. But in the live stream I covered with him, it was told that he was a sovereign citizen mentor.
Oh, very well. Look for that invitation on the breakout screen. And Destiny, if you'll put that on there for Mr. Schrader, for the officer in court security 2.
What time? So it's November 12th?
The motions hearing is November 12th at 1:30, correct?
1:30. Okay.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just put the 2 of them in a breakout room. Okay, anyone else that you want me to address that I haven't yet, Destiny?
I have no others on my list, Your Honor. Just like I said, it does seem that Mr. Matthew Schrader is still on the hearing with us, so I didn't know if he needed anything else from the court after his hearing.
Let's look at that again. On the record again in D 2025 TR 434, State of Kansas versus Matthew Kyle Schrader. Jared Regier still for the state. Mr. Schrader still on the docket after being excused.
I didn't hear a recess.
I'm sorry, what?
I just didn't hear that I was given recess.
Okay, I'm sorry you've had to wait this long then, but I am releasing you at this time as you did have your motion hearing set. 11:12 at 1:30.
Yeah.
All right, you may go, sir. Thank you.
All right. Thanks.
Well, we'll see what happens when he comes back and if he comes back. But I can say with this sovereign citizen group, they definitely show up for court. But who knows what type of monkey wrench he's going to throw in the program or some type of delay he's going to come up with. But we'll see, because all of them are pretty much at the same stage right now. So we'll see what happens on the next hearing. All right, now you finished with the first hearing. Let's go.
Then we'll move on with the Schrader case. Matthew Schrader.
I'm here.
All right. This is State of Kansas versus Matthew Kyle Schrader, case number 2025 TR 1342. Jared Regier appears for the state. Terry Hulskamp appears as Butler County Counselor. Matthew Schrader apparently representing himself. This matter comes before the court at this time for what the docket sheet reflects is a motion hearing. Now, Mr. Schrader, what motion do you have before the court?
So, Your Honor, I know that today's hearing is set for the motions hearing for the subpoena I submitted, but I would like to withdraw that subpoena I submitted. I made a discovery request and I was able to get all that I needed. And also, Mr. Regier and I have been working on resolving this matter outside of court proceedings. We had an in-person meeting on November 3rd, and during our meeting, I was able to provide him a valid insurance. And then the next day I was able to get the VIN inspection. And then I'm sure you're aware, but the registration offices, their appointments are out a month and a half, but I was able to get in line at 4 a.m. and I was able to get that done on like November 5th. And then on the 6th, I brought the proof of that to Mr. Regier's office and they got that scanned in. So, this was my first offense. I just bought the vehicle and I moved it an eighth of a mile and was cited for it. But so it's really a small deal. But since it's my first offense, I took all my corrective steps to remedy the issues. So I was just hoping that since I've provided the necessary documentation and we're in full compliance now. So I was hoping we can just resolve these matters today before the court.
Well, look at that. The other two have lawyers, and now he's trying to settle his case. I don't know what happened, but they all made a quick turnaround. Let's continue.
Mr. Regier, what is your office's perspective on the current status of this Schrader matter?
Your Honor, as a preliminary matter, the state would be requesting a ruling one way or the other on the issue of the subpoena. I believe County Councilor Hulskamp had filed a motion, or rather a response to that, and I think he's in a better position to address that than I am. At least that would appear to be the first issue that requires resolution from the state's perspective.
My understanding, Mr. Schrader, that you're dismissing any further claim for records or materials from the county sheriff's office. Is that correct?
Yeah, anything that I had on the subpoena, I'm ready to withdraw it.
All right. Mr. Hulskamp, any comment from you?
No, Your Honor, as long as the subpoena is being withdrawn, I don't think there's any further argument with respect to the issuance of the subpoena.
Very well. To the extent necessary, the court will grant the request to quash the subpoena is no longer being necessary or requested. So the subpoena is quashed in its entirety, Mr. Hulskamp. And I can go ahead and release you from the meeting if you have no further business here.
Thank you, Your Honor.
Very well. Okay, Mr. Regier, with that accomplished, now where are we on this Schrader matter?
Your Honor, this is a case where it would appear that between the previous hearing and today's hearing, some additional documentation was provided to my office. At this juncture, the state is not aware of any legal reason to dismiss either count. However, in the interest of resolving the matter today, upon a successful waiver of counsel, the state would be prepared to dismiss count 1, failed to register a vehicle in exchange for a plea as charged. Count 2, no proof of insurance, and at the time of sentencing, recommend minimum fines, court costs, a suspended jail sentence, and non-reporting probation.
Mr. Schrader hasn't provided proof to your office that he had valid insurance at the time?
Your Honor, the state is aware of a proof of insurance at some time. However, the state's information is that was not valid at the time of the offense.
All right. Do you agree with that, Mr. Schrader?
Yes.
Okay. Though the purpose of this hearing is not necessarily to allow you two to engage in plea bargaining,
Right.
Mr. Reguera has made an offer to you to resolve both of the charges in your case. You would plead to the no proof of insurance violation in return for the state's dismissal of the other count. Are you interested in that?
Potentially, I'd like to know more about what that would entail, and then
Well,
also.
okay, I can tell you, the no proof of insurance is a Class B misdemeanor, punishable by a minimum fine of $300 and a maximum fine of $1,000. Also, up to 6 months in the county jail is authorized. But there is no mandatory minimum connected with that
Okay.
particular charge.
All right. I'd be interested to know if a diversion is an available option for me.
It's a fair
Because it's
question,
so-
Mr. Regier. Can you answer it?
Your Honor, short of the defendant actually submitted an application for diversion, I cannot say for certain at this juncture. That process, from what I understand, requires an in-depth analysis, and I do not have the ability to make such an analysis on the record here for purposes of today's hearing.
But it's theoretically possible. There's no diversion guideline that would preclude it as a matter of course. Is that a fair statement?
The state would consider that a fair statement, Your Honor.
All right. Mr. Schrader, I am inclined to allow you one continuance for the purposes of an application for diversion, which you need to pursue immediately. As far as getting a copy of the diversion application, how would he go about doing that, Mr. Regier?
Your Honor, the state's information is that all information concerning diversion is found on the Butler County website, bucoks.gov.
Okay, Mr. Schrader, apparently it's an easy process and that is posted and accessible online.
Okay,
I don't
I
think
can
it
get
takes
on
a
that.
real long, excuse me?
I can get on that immediately after this meeting.
Now, you let me know in the comments if you're happy that he turned over this new leaf. Do you think it's temporary, or you really think he came around like the others?
All right, that would be in your best interest to do so. Again, I will grant a continuance for that purpose. I'm going to allow about a month for that process to take place before I reschedule. Mr. Regier, it's the court's current understanding that you have a tendency to be involved in all of these traffic matters, but you generally wouldn't have a conflict on Friday mornings.
Generally speaking, I would not have a conflict in my experience, Your Honor.
All right, I'm going to reschedule this case I'm going to do a Zoom review on it, Mr. Schrader.
Okay.
11 o'clock a.m. on Friday, December 26th. And I trust the clerk's office has a valid email address for you so that you can be sent to Zoom information.
Yeah.
Okay, that's important.
Yeah.
Friday, December the 26th, 11 o'clock a.m. by Zoom. This court will conduct a status review and the review of a diversion application status, which Mr. Schrader is going to immediately fill out and send in. And we'll do further scheduling at that time as this court deems necessary. So this is not, Mr. Regier, a trial setting in which subpoenas are necessary.
Very good, Your Honor.
Friday, December 26th, 11 o'clock a.m., Zoom status conference. Again, Mr. Schrader, the sooner you can get that application in, this is a busy time of year for all law offices, especially the county attorney's office. So the sooner you can get that in there, the better. And I'm sure they'll give you a prompt response.
Okay, sounds good.
All right.
Your Honor, we will need an email address for the defendant. We don't have one on file.
Mr. Schrader, I thought you said they had that information. So you did multiple
Well,
filings
prior
with the
to
states without
no,
providing your email address?
well, prior to this meeting here, I called the clerk's office and I gave them my email in order to get the ID and password for this meeting. And so they sent it to my email.
Destiny, do you know about that?
Your Honor, on the 10th, I was sending out the Zoom codes for the defendants, and then there is marked on 11/10 at 11:22 that there's no email to send defendant the Zoom information. And that was on Monday.
Yeah, you have any problem with just stating it here, Mr. Schrader?
No. If I can give it here.
Just go slow, okay?
Yeah. All right. It's SCHRADER.
Thank you, Mr. Schrader. That will facilitate good communication. County Attorney's Office is so advised.
Thank you,
And I
Your Honor.
post it's customary, Mr. Regier, for these things to be submitted electronically to your office by email?
Yes, Your Honor.
Okay. And if you don't have an effective email address for the county attorney's office, I'm sure you can call and get one, Mr. Schrader. Just call the county attorney's office if you
Okay.
need the diversion coordinator's email address.
Okay.
Okay. Mr. Regier, is there any other business that we need to conduct on Matthew Kyle Schrader at this time?
There is one final matter, Your Honor, if the court will permit me.
Yes?
Your Honor, as previously observed by the court, count 2 does appear to be charged as a Class B misdemeanor, which does require booking pursuant to KSA 21-2501 subsection B. The state's information is that the initial hearing back in September, the court did make certain orders concerning booking and bond over the objections of the defense on the record. State's information is that as of today's date, an appearance bond has not been successfully executed in this matter.
Your Honor, there is one in Judge Webster's queue to sign. I just believe it hasn't been signed yet.
There's a bond for her to approve?
An appearance bond, yes.
Okay, so Mr. Schrader, you took care of this then?
If so, I had went to the jail, signed some papers about the bond. Yeah.
Okay. And so you did go through booking and processing then?
Yeah.
Okay. Well, if there's a bond that was generated, almost certainly you did. Is this an OR bond or a surety bond?
Your Honor, the state's information is the court did authorize an own recognizance bond.
Okay. All right. Well, that apparently will be signed by Judge Webster and become part of the case. And that should address Mr. Regier's concern regarding booking and processing.
Quite so, Your Honor.
Okay. If there's nothing further, then the Matthew Schrader matter will currently be in recess at this time. You can leave the meeting if you so desire, Mr. Schrader.
Thank you.
Well, it looked like the trio that was working together finally came to a close. Now, I want to follow up on this next hearing, but I want to do some digging and find out what made them change all of a sudden. If I can find out, I'll let you know. If I can't, I'll still let you know when I come back on this next hearing. So I hope you enjoyed both videos. You're all up to speed once again, and I'll see you around on the next one.